If you have been served with divorce papers, you might be confused about what to do next. In this video, we'll discuss your options and how to respond. These steps are explained from the view of the person who did not file the divorce or the respondent. This video is intended as general legal information about divorce in Oklahoma. This is not legal advice. If you are feeling unsafe or experiencing domestic violence, please visit the websites in the description or call the numbers below for emergency resources. When the petitioner or the person who has filed the case officially serves you with the petition and summons, the case has begun. As the respondent, once you've received these documents, you have 20 days to respond to keep your rights in the divorce. You have two main options for your response. These options depend on whether you agree with the petitioner's statements in the petition or not. If you agree, you can sign an entry of appearance and waiver. If you disagree, you can file an answer and counterclaim. If you agree with everything in the petition, you can sign a document called an entry of appearance and waiver. This document usually comes with the petition and states that you are knowingly giving up your rights to any notice of future steps in the divorce process. You agree on all major issues in the petition, and you will accept the petitioner's version of the decree of divorce. You will need to sign it and file it with the court. You must wait at least 24 hours from the time the petition was filed before you sign and file an entry of appearance and waiver. If you do not agree with the petition, you can file an answer and counterclaim disputing the petitioner's claims and stating your own. In your answer, you respond directly to each of the petitioner's claims and say that you either agree or disagree with each paragraph of the petition. You can include the reasons why you disagree if that information is important. For example, if anything in the petition is incorrect, you can state that you disagree and then provide corrected information. In your counterclaim, you can say what you want to happen in the case. Here, you can ask for alimony, custody, visitation, child support, division of property, and change of last name. This is your opportunity to tell the judge what you want in the divorce. If you do not make your wishes clear in your answer and counterclaim, you will lose your right to bring it up in court later. Once you've filled out your answer and counterclaim, you must sign it in front of a notary, which may cost money. Next, you must take the notarized document and copies to the court clerk's office in the county where the divorce was filed and submit it for filing. The court clerk will keep the original and give you stamped copies. You must take one of the stamped copies the court clerk gives you and mail it to the petitioner or their attorney, if they have one. There is no fee to file an answer or counterclaim. If you fail to file either an entry of appearance and waiver or an answer and counterclaim before your 20 days are up, you are considered in default. The divorce can go forward without your participation. If you are in default, the petitioner is not required to keep you updated with the case's progress. It is important to understand the deadlines involved in a lawsuit so that you can protect your rights. To learn more about default, please watch our Court Basics video on default judgment. Once you've submitted either an entry of appearance and waiver or an answer and counterclaim, there are still several steps in the process before the divorce is final. Please watch our Part 2 video, What are the steps of getting a divorce?, to learn more. Remember, divorce can be complicated. There are a lot of steps in most divorces, and every case takes a different path. If you need a lawyer or want to learn more, here are some resources that can help. This was brought to you in part by the Oklahoma Access to Justice Foundation and Legal Aid Services of Oklahoma. Thanks for watching.